and we may have an early class. I am hopeful that you actually do participate in today's group assignment. And many people seem to just disappear after the break for whatever reason. And I'm going to start noticing that, because if you're trying to get extra credit and you didn't do very well on the midterm, you really need to stay in class and do all the exercises that I suggest for you. Because I think 10% of the grade is participation, so if you just fly after the break and you're not doing well in class, you're just hurting yourself. And the exercises that I'm giving you are designed to be practical, that will help you in your real life, not just in a class. So having said that, today is an incredibly important lecture. We're talking about how to legally form your business. So how many people in the room are planning on starting their own businesses when they graduate, being an entrepreneur? Not too many. And how many people are interested in possibly working for a startup? Might have a friend or a colleague. All right, so a fair number of people. Well, that suggests that the majority of you plan to work in firms that are already established. So some of what I'm telling you may not be incredibly helpful, but you still need to know it. Because even if you start off in your business life working for someone else, whether it be Google or Facebook or Yahoo or, again, another startup, perhaps someday you will start your own business. And in order to protect you legally, it's incumbent upon me to lay out what the different possibilities are for you forming your own company and what the options are, and also from a tax perspective, what are the different nuances versus an LLC, an S Corp, and a C Corp, and also a sole proprietorship. And I will also tell you by the end of today's lecture why I think a straight partnership is a very bad idea. So let's start off at the top talking about the LLC. An LLC is what we call a limited liability company. Limited liability company means that the owners or the stakeholders in the limited liability company are protected to some extent. And when I say protected, I mean that their personal assets are protected. And pretty much all of these different legal ways of forming your business suggest some way to protect your personal assets. Well, you might say, Mr. Silberman, when I first start my company, I probably won't own a home, and I probably won't have a car, and I'm going to have a lot of student loan debt, so I don't really have any assets. Well, that may be true, but you have to think about what's happening in the future. Because as you go through your life, and you will start to amass assets, you'll probably have a home, or other personal assets, even jewelry. And if for some reason you got into litigation or a lawsuit very early on in your business life, and somebody got a judgment against you in California, that judgment is good for 10 years. So again, you might be saying, well, you know, to start out with, I don't really have any worries about being sued because I don't own anything. I'm judgment proof. But you have to think about the future. So in doing that, let me start off by talking again about the LLC, the limited liability company. I'll tell you some of their benefits and some of the weaknesses of the LLC. One of the benefits, of course, is that it does protect your personal assets if it's done correctly, if it's structured correctly. Some of the sort of other benefits for an LLC is that it's a very informal type of way to hold your business. Unlike corporations, you don't have to have monthly corporate meetings, and to set up your LLC is pretty basic. You have a filing with the Secretary of State, here if you're doing it in California, and you fill out a form and you send in a check. But every year that you want to keep your LLC going, you have to pay at least $700. And if you earn a profit, then the amount of money you're paying to the Secretary of State is commensurate with how much you make. But the minimum that you're going to pay is about $700 to keep your LLC going after your first year. Now, when you first form your LLC, you can drive up to Sacramento with your form and pay them a fee, or you can mail it. Do you need a lawyer? No, you really don't. It's a pretty easy form. You can go to the Secretary of State website, and there's a section called Business Portal. And really, all the forms you need are there. So I really don't understand why a lot of people will go to a lawyer to have them set up a corporation or an LLC, because you're just basically spending money for nothing. The forms are really easy. I mean, you're basically just putting down the name of the corporate officers, your business address, and perhaps a little bit about what type of company you're going to have. But beyond that, it's not really very complicated. Now, the other thing you can do, which is important, is to find out if your name is available. So you might have a great name for your business, and we'll talk a little bit about names in a moment. But let's say that you've got a great name picked out for your new business, and you want to make sure that nobody else has that name. Well, again, here in California, you can simply go to the Secretary of State website and do a business name search. It's free. Why pay a lawyer $1,000 to do a name search for you when you can do it yourself? It doesn't make any sense. I mean, even companies like LegalZoom, that is sort of a hybrid between doing it yourself and hiring a lawyer, they will prepare the paperwork for you, but they're going to probably charge you $300 or $400. I mean, that's just crazy. Especially when you're starting out, you want to make sure you're as lean as you possibly can be. So unless you have some really complicated legal question, you can probably do this yourself. Now, some of the detriments of having an LLC is that the IRS will treat you as a company and an individual. So if Albert is opening up an LLC, he is going to be facing what we call double taxation. He will be facing taxation on his corporate profit and also his individual profit. Now, there are ways of handling that from a tax perspective, but pretty much the LLC is going to almost guarantee double taxation. So that's probably one of the major downsides of the LLC. The other downside, and this isn't really that prevalent because LLCs have been around probably for about 25 years, but believe it or not, there's some judges that will not recognize the LLC as a proper legal formation. So if you're attempting to protect your assets and you've done everything correctly, you've protected your name and you filed the paperwork correctly, you could still be facing a problem in some jurisdictions. That's why, again, if you enter into a contract with a foreign corporation, and when I'm saying foreign, I mean outside the state of California, you better have something in your contract saying that any litigation gets handled in the venue or jurisdiction you're doing business. So if you're doing business in Los Angeles County, you better make sure that your contract says if there's a dispute, then proper venue will be Los Angeles County. Otherwise, you're going to be paying a lot of extra money and expenses to have your case litigated outside your comfort zone or your residence. So, again, probably the main benefit of the LLC is that it does protect your assets, and it's very easy to set up, and it's very easy to maintain. Any questions about the LLC before we move on? Yes, sir.
What do you mean by the double taxation? So they
Okay.
tax you as a business and a...
Yeah, so the question becomes, what is this double taxation if, let's say, you have your own LLC, and your LLC earns $1 million, and you have a salary of $200,000. Then, if you own the LLC, if you're the main stakeholder, then you're going to be taxed based on that LLC's profit. That's one taxation or one tax bill. And then you'll also be paying tax on your own personal salary. If you have an S-Corp, which we'll talk about in a moment, you may be able to avoid that double taxation. So if you're the main stakeholder in the corporation, you're not going to be faced with getting taxed on your corporate salary and your corporate profits at the same time. Does that make sense?
So if you're not actually pulling money out of your company, since it is a starting company, you kind of want the money to keep generating?
Yeah, so in the beginning, you're probably not going to have any profits and you're not going to have any tax issues as far as getting taxed on your corporate profit. It's just when you start making money, when you start showing a profit.
Okay. But even if your company is making a profit and you personally are not taking any of that profit?
It doesn't matter. If you're getting a salary, you're going to be taxed on that. Yeah, I mean, if you got nothing, if you're just donating your time and energy, then you wouldn't have to worry about it. But most people that work in corporations, they want something. They're not working for free.
Well, if you're starting your own company.
Yeah, if you're starting your own company, then you don't have to worry about profit issues probably. Or, you know, probably you're just going to only get taxed one time. And you might not have any taxes in the beginning. But remember that if you show a loss in your company for more than 3 years, then the IRS is going to consider that a hobby. And they're going to close you down. They're not going to allow you to take itemized deductions because it looks like you're just working some kind of scam. So you get a lot of meals and entertainment, and you can write that off your tax returns. So this is not a tax course. I don't want you to think that you're going to have to worry about doing any complicated tax problems on the final exam. I just want you to know these basics about how this double taxation could happen if you are showing a profit and you are taking a corporate salary. All right, so let's move on. Actually, I'm going to talk about partnerships next. My view is that partnerships, or what we call straight partnerships, is a very dangerous idea. And I may have alluded to this in previous classes, but the reason that a partnership is a really bad idea is because you are responsible for everything your partner does and everything your partner does not do. It's almost like a marriage. So when it goes badly and you end up in divorce court, then it starts costing you a lot of money. So let me give you an example. I had a client who owned a taxi company, and let's say he was partner A, and his other partner B was responsible for paying the insurance on the vehicles. Now you can imagine that liability insurance for a taxi cab company is pretty important, right? Imagine if I have a taxi cab driver who is intoxicated and he hits some lady walking across the street, a pedestrian, and injures her badly. Now, if in fact that was an employee and was acting in the course and scope of their employment, under the concept of respondeat superior, which we talked about in tort law, under this legal theory of respondeat superior, as long as that employee was acting in the course and scope of his or her employment, which means he was just doing something to benefit the employer, picking people up, taking people to the airport, whatever they were doing. And while they were in the course and scope of their employment, they ran into this older lady walking across the street and injured her badly. And now she has $1 million in personal injury losses.
But you said he was intoxicated, so how doesn't that break the laws, therefore?
So he could be subject to criminal liability.
Oh, okay, but not.
And also he could be making the company liable in a civil case. So the old lady could press charges criminally, and the district attorney could. But remember, there's a question on your midterm asking, is it possible to have a civil case and a criminal case arising out of the same set of facts? So this is a perfect illustration where there could be. But for this examination of partnership law, we're primarily concerned with the civil liability. Here, and I'll show you why in a moment. Because partner B was responsible for paying the insurance, you can imagine what's going to happen. In this particular scenario, partner B forgot to pay the auto insurance. Now, who's this lady going to sue? Is she just going to sue B because B forgot to pay for the insurance? Absolutely not. The old lady's going to hire a lawyer, and the lawyer is going to sue everybody in sight. She's going to sue the cab company. She's going to sue partner A and partner B. So that's why partnerships are incredibly dangerous. Again, you're responsible for everything your partner does and doesn't do. This was an example of being responsible for something that your partner didn't do, which means the partner did not pay the auto insurance, subjecting the company not only to liability, but almost putting it out of business. Now, that's an example of what we call an omission, or a failure to act prudently, which is imposing liability for both partners. Now, I'm going to talk about a situation, actually the same partners, where this partner B did something else. Partner A, again, we'll stick with the same taxi company, was in Las Vegas for a taxi cab convention, or a taxi cab owner convention. I don't know what they do there. It doesn't really matter. The point is, while A was out of town, B decided to get creative with their marketing budget and called a representative from the Yellow Pages, which is almost never used anymore, right? How many people use Yellow Pages these days? Hardly anybody. We probably use the internet if we want to get information, right? So this was maybe 15 years ago. This guy was at this taxi cab owners convention, and B entered into a contract for $5,000 a month with the Yellow Pages. Now, A was pretty upset when he came back from the convention and found this invoice on his desk. He started yelling and screaming at B. B, what the heck did you do? I didn't authorize your paying this $5,000. Again, who do you think the Yellow Pages is going to file a lawsuit? Against B, the one who signed for the corporation? They should have had a corporation. It's a partnership. No. They're going to sue A and B because they're involved in a partnership. Do they care who pays the $5,000 bill? No. As long as their bill gets paid. And if it doesn't, the Yellow Pages is going to sue both of them. Now, you might ask yourself, could A sue B? Yes, of course. But what if B is insolvent? What if B has no money? Now A either pays this $5,000 bill or faces a lawsuit from the Yellow Page company and gets slammed with a judgment what's good for 10 years and ruins his credit rating. So I hope I've scared you a little bit about partnerships. A lot of people tell me, you know, after I graduate from college, I'm going to go into business and I'm going to form a partnership with my best friend. We both have some great ideas about how we would run our company. Bad idea. Forming the company is fine with a friend, right? That's not the problem. It's just don't have a partnership. Now you might say, well, isn't there some form of partnership that's not as dangerous? There is something called a limited corporation. Not an LLC, not a limited liability company, but a limited, it's a limited partnership, not a limited corporation, a limited partnership. And the way a limited partnership works, is you have a general partner and a host of limited partners. A general partner and a host of limited partners. This is a little better than just a straight partnership. It's a little better because the limited partners have limited liability. If you form a company as a limited partnership, which used to be very, very popular about 25 years ago for tax benefits, not so much anymore. But if you're a limited partner and you invest $10,000 into this limited partnership, your liability maxes out at $10,000. So you can't be sued for more than $10,000. Now, if your liability is sealed at $10,000, then you would ask yourself, well, what happens to the profit? Also, it's going to be sealed at a certain point. Because if you're accepting a limited liability position, you're not going to reap the same benefits as the general partner who's taking a lot more risk. Risk is usually commensurate with reward. The more you risk, the more you reward. But in this particular scenario, if you only want to limit your liability to $10,000, then you're not going to get as much of the share of the profits as the general partner. You might say that's okay. At least I don't have that liability. I'm really concerned about liability. I'm a successful entrepreneur in the Silicon Valley, and I'm worth $20 million, and I don't really care so much about how much money I'm going to be taking out. I have a pretty good nest egg. I just don't want to get sued for everything I'm worth. Does that make sense to everybody? Okay. Anybody have any questions about the difference between a general partnership and a limited partnership? I misspoke earlier when I said limited corporation. There is no such thing. There's a limited liability company and then different types of corporations, which we'll talk about in a moment. But does anybody have any questions about the difference between a garden variety partnership and a limited partnership? Okay. Let me talk now about one other type of corporation which may be attractive to some of you. Some of you may be interested in being socially aware. You might want to open up a nonprofit company, which is a 501c3 company. You might have a great idea for solving the problem with our current drought situation here in California. Or you might have some great idea for a new vehicle that will save money and also have clean air emissions, and it can be sold throughout the world. And you're not really focused so much on profit, but you are focused on getting your product to market and helping the environment. Now, can you still make money as a 501c3? Absolutely. Right? Some companies after 9/11 were actually accused of pilfering and taking too much profit when some of the money, or most of the money, was supposed to go to the victims of 9/11. A lot of the people in the corporate offices were taking money for themselves. But if you're running your 501c3 company profitably, you might have a very nice salary. You might have a $500,000 salary, but you're not in business to make a profit. The philosophy of your business is to solve a social problem, to make clean air vehicles, or to solve the drought problem, whatever it is. But if you're the CEO of that nonprofit, you might be very wealthy, and you might be doing a lot of good. So when you're starting your 501c3, it's not so difficult. You just have to convince the IRS that your main purpose in establishing your 501c3 as a benevolent purpose. That your 501c3 has been initiated to solve some kind of problem. Anybody have any questions about that? The 501c3 is actually organized through the IRS, and they have a special form. Now, you can also start a nonprofit corporation here in the state of California by filling out the appropriate form with the Secretary of State and filing a fee. I think it's $70. Imagine for a moment that you want to open up a credit counseling company. You may know that many people have damaged credit because of the recession that we may still be in. Although Washington tells us something else, we may still be in a situation where there are a lot of jobless people and a lot of people have very bad credit. So if you wanted to open up a credit agency where you're helping people restore their credit, it is illegal to take money up front in many states. However, if you organize yourself as a 501c3 company, you can avoid many of the regulations that you would have normally with a privately held credit repair company. If you're interested in that area, let me know. I can give you some information about it. But the point is you can have a very, very excellent living and make a really good difference in the world by heading up a 501c3. All right, any questions about that? All right, now we're going to talk about sort of the most critical and fundamental ways that most people here in the Valley start their companies. And I would argue that if you're a budding entrepreneur and you're looking for startup capital or an investment, you want an S-Corp. You want to start with an S-Corp. And there are many reasons for that. No double taxation. No double taxation with the S-Corp. So you're not facing personal liability and corporate liability. You can choose. And you can raise money. A venture capitalist will take you pretty seriously if you've already formed your S-Corp. Now, on the downside of the equation, there are lots of formalities involved. You have to have corporate meetings. You have to have corporate minutes. You have to have a board of directors. Also, as an S-Corp, you are not allowed to sell your shares of stock to another company. You can sell up to 100 individuals, but you can't sell shares of stock to a company. Again, to form an S-Corp is very easy. Here in California, and most states probably have the same vehicle for doing this, you go to the Secretary of State website, you do a name search to see if somebody's taken your name, and if your name's available, you fill out the form, and you send a check, I think it's for $100. Voila, you've got your corporation. Did you need to go to a lawyer? Probably not. You can do this yourself. Now keep in mind, if you leave a blank on the form, they're going to kick it back to you. But I've seen lawyers forget to fill out the information correctly as well. So it could happen either way. Maybe less likely, but maybe not. So the next question you probably have in your mind is that, well, this S-Corp sounds pretty good. But what if I want to sell shares of stock to another company? What if I've enticed Google to be involved with my company as a joint venture? Well, I can't sell them any shares of stock, can I? Because they're a company. So what do I do? I want to work with Google. I want them to be involved in my company. And they want to buy some of C-Corp. Absolutely. I can dissolve my S Corp and open up a C Corp. Can I use the same name? Probably. If I protected it initially, it's probably still available. So, as there are benefits with this C Corp, one of which being able to sell shares of stock to a company, you still have the same formalities as the S Corp. Corporate minutes, board of directors, shareholder meetings, disclosures, compliances. And you can probably guess that the other downfall of the C Corp is the double taxation. But now you're a real player. Now, as a C Corp, you could be selling shares of stock in Wall Street. You could be enticing even bigger investors to buy part of your company. But starting out, usually an S Corp is going to be okay. You don't want an LLC. I know very few angel investors or people that provide capital that will invest in an LLC. It's just not done. Why would they? They want to be able to buy and sell their shares of stock at some point in the future. So you may have watched programs like Shark Tank where they're trying to take an equity position in somebody's company, and if those companies are LLCs, I doubt that they would invest. They might say, hey, come back after you formed your S Corp or your C Corp, and then we'll take a look at it. Okay? So any questions about, yes?
And the forming of your S Corp is just simple paperwork?
Simple paperwork. Make sure that your name's available. Go to the Secretary of State website. It used to be Deborah Bowen here in California, I think. Doesn't really matter. The website hasn't changed. They have a business portal, and they have a form section. You fill out the form. You can even use your own writing. You don't have to type it. Send in a check. If you want to expedite it, you can drive it up to Sacramento if it's urgent. I think they charge a special fee for that, like another 30 bucks maybe. But if you send it in the mail, you'll probably get it back within about 30 days. Voila, you've got your corporation. No magic, no mystique, no mystery. Anybody can do it. Any other questions? Yes?
So you said with corporations, you need to have things like the shareholder meetings, board of directors.
Yes, formalities.
So, how would you prove that you've had shareholder meetings? How do you even prove that you have shareholders? Because realistically, if you're
You'd have records of that.
Yeah, but realistically, if you're just starting a company, I mean, you can evaluate your own company at whatever you want. Right?
Yeah, I mean, if it's just you, then you'll just say I had a meeting with myself or
exactly.
record
So
it.
is that what you say? You just say you had a meeting with yourself?
Yeah.
And you record it once a year? Once every month? Or?
Yeah, it depends on what your corporate bylaws say. So you can structure it differently. You can kind of plan it yourself. Usually every 6 months is a good idea. But that would all be laid out in your corporate bylaws.
So if you're having a meeting with yourself, what are you doing?
Go out to dinner and ask yourself some questions. But
well, realistically, what would you be doing if you had a group of 4 or 5 people?
Okay, so realistically, you would be talking to them about the state of your company. What is your projection for the year? What type of expenditures are you facing?
So is that the thing that you would need to show them? That
Yeah.
You actually have?
How healthy is your company?
Okay.
Yeah.
Can you show that to the IRS or the state of...
So you would show that to the state of California if you got audited by the Franchise Tax Board, or the IRS if you got audited by the IRS. Yeah, record keeping is very important. Not so much for the LLC. Once you formed it, it's not a big deal. Now, I will talk about 2 other things actually. One concept that I want to make clear is how easy it is to destroy your corporation. So you spent this time and energy and money to set up your company correctly, However, now you're facing litigation and somebody's trying to reach your assets and they're trying to prove something called ultra vires. All right, let's use the example of Mark Zuckerberg, okay? The guy's a billionaire, I guess. I don't know. He's probably worth a lot of money. And when he started Facebook, he made sure that his company was set up properly, legally. You can imagine someone of his stature being hit with lawsuits for all crazy things, all kinds of crazy things, because he's a target. Everybody in the world knows that he's incredibly wealthy. He doesn't really hide it. It's pretty public information. So if Mark Zuckerberg set up his corporation properly, it will be hard to reach Mark's personal assets, his mansions or his jets or whatever he has. I don't know. But remember, all these legal structures you're putting in place to protect your personal assets. That's the whole reason why we're doing it. So you've taken all this time and energy, and maybe you hired a lawyer to set up your corporation properly, and now you received a letter from your lawyer saying somebody wants to sue you, and I think you've got a big problem here because your corporation is about to be attacked. We say that the corporate veil is about to be pierced. You see, a corporation is sort of like a human being, but it's not really. It gets taxed like a human being, but it's an entity. It doesn't breathe, it doesn't eat, it doesn't need medical care, but it acts like an individual. It acts like a person. It's taxed like a person. If we destroy this protection between the person and the company, then we can reach into the individual's assets. Take Mark's jets away or his mansions or whatever he has. If we file a lawsuit against him for copyright infringement and we win, and if he makes the mistake, which he probably wouldn't, of doing three things. One, certainly wouldn't be the case for Mark, would be underfunding the corporation. Underfunding the corporation. Let me give you an example. I have a contracting company, it's a hypothetical, and I enter into a contract with San Jose State to repair all the roofs on the various buildings. Let's say the roofs are deteriorating. And I enter into a contract with the university, and it's a $2 million contract. But I only have $10,000 in the bank. And I'm a corporation. That's not going to fly. What happens if San Jose State needs to sue me because I didn't finish the work on time, or I didn't do the work properly? What are they going to get? 10,000 bucks. That will destroy my corporation. It puts potential plaintiffs in a very risky situation. Because I'm underfunded. I shouldn't be allowed to be in business, let alone bid for multi-million-dollar contracts. Does everybody follow that? Second way to pierce the corporate veil. Fraud. Okay? I leak something to the press that we're about to acquire Google. Right? Facebook's about to acquire Google. And based on that news, what's going to happen to our shares? Are they going to go up or down? Probably going to go up. Right? Probably going to go through the roof. Everybody's going to want to buy it. Well, what if that's just a lie? I just made it up to increase our own earnings. Happens all the time. Then, what I've done through this fraudulent activity is I have pierced the corporate veil. Now I no longer have protection. Now there's one final way. And this is the most, I don't want to say popular, but most common way of destroying your corporation. It's Edgar, right? Edgar has a company. Edgar has a corporation. And from time to time, his grandmother gives him presents. For his birthday, when he's going to graduate from state. She loves Edgar. She's going to give him some presents. She writes a check to Edgar, and he puts it in his corporate account. He just started his corporation. Says, "Thank you very much, Grandma, for the $5,000. I'm going to put it in my corporate account." He just destroyed his corporation. We call that commingling. Commingling. That means we're putting personal funds, like a gift from our grandmother, into our corporate account. Actually, what we see more of is people embezzling from the corporation and using the corporate checking account to pay for personal stuff. I saw this great suit at Neiman Marcus the other day, and I'm going to write a check out of my corporation. The Mr. Silverman Corporation, because I really want that suit. I have just destroyed my corporation. If I ever get sued by some plaintiff and they want to reach my personal assets, the first thing they're going to do is they're going to subpoena my bank accounts and see what kind of activity is going in and out of those accounts. And if I'm using my corporate checking account to pay for personal expenses, or like the example with Edgar was illustrating, if I'm putting personal funds into my corporate account, I have destroyed my corporation. I have allowed the defendant, or rather the plaintiff, to pierce the corporate veil. Yes?
How do you get money into your account if it doesn't start off with your personal?
You have separate accounts. You have separate accounts for your personal stuff and separate accounts for your corporation.
But the grandma had a different account than the corporate.
Oh, that's okay. You just put it in your personal account.
So I would,
Grandma gives you a check.
If grandma gives me a check, I would have to put it into my personal account.
Exactly.
Then I would have to move it into my...
No, you don't touch it. You just leave it in your personal account.
What if I want the corporation to have the money?
You can't. The corporation can't get that money. Otherwise, you destroy the company.
How does a company start without any money then?
So you can make a gift to your own company. You can make a personal gift.
So isn't that what the grandma did?
She's giving the gift to you.
I think, what if he's the CEO and he's starting up the company?
Yeah.
Can he move that money from his personal account and say it's his gift to his company?
Yeah, for starting up your company,
Yeah,
sure.
starting up.
But you can't have a consistent stream of funds coming from one account into the other. But to
So
start up your
it would have to
company,
be gifted then.
you can put cash in your company to start it up. Yeah, no problem. And you can write yourself a note. Say, look, I put $10,000 into my company, and whenever I make that money back, the company owes me that money. That's totally fine. We're just concerned about the source of the funds. If it's from a third party, it's a third party gift, it can't go into the corporate account.
If
it's an investment, that's a different story.
Okay,
Yeah, if somebody's investing into your company.
So if you give, say, your grandma shares in the company
Yeah.
for doing that.
Now, in an LLC, does not have stock, but you can have an ownership interest. You can buy a part of the LLC, and that's fine. You can buy shares of stock in an S Corp or a C Corp. But if you give somebody a personal gift, that needs to go into the personal account. And that's very strictly scrutinized. Any questions about that? All right, I'm going to talk about a couple more topics, and then I can give you an assignment, and then we'll go on a break. Many people, as a matter of fact, I just talked to somebody today, and he wants my advice on getting funding for a motion picture. I also dabble in the motion picture industry, a little bit. And he said, you know, Mr. Silverman, I'd love to talk to you tonight because I'm meeting with this distribution company next week. And I know you have a lot of experience in the entertainment business. And don't worry, because I have a DBA. I've already protected my business. You have what? A DBA? Doing business as? Zero protection. DBA means you went down to the city hall, you paid him 35 bucks to get a fictitious business name. It doesn't protect anything, except maybe that name, and that's even questionable, because that might just be in this county, but what if somebody's using your name in another part of the state, or another part of the country, and you haven't protected it? We'll talk about intellectual property next week. But the point is that the DBA will not protect anything. Certainly not your personal assets. It would just crack me up. Oh, don't worry, I've got a DBA, so I'm protected. So, really? So you mean to tell me that you're pitching your concept and you don't have an LLC or an S Corp or a C Corp? And he told me he's pitching his idea to a major studio? Like, are you an idiot? The only thing that happens with a DBA is that after you get your fictitious business name, you publish it in a local paper and you pay them like $100 bucks to protect your name in the county. That's all. One more thing I'm going to talk about. And that is, how do you establish your corporate bank account? Most consumer banks, Bank of America, Wells Fargo, Comerica Bank, will allow you to have a corporate account. In order to open up that corporate account, you have to have proof of your filing, which means a stamped copy of that form we talked about, not just a copy of the one that you sent in to the Secretary of State, but the one that came back after they cashed your check. The one that was stamped. Now you're official. So you need your officially stamped document, your articles of incorporation, and an EIN. An EIN is your employer identification number. You will not get your corporate account without one. How do you get it? Very easy. You call the IRS. The longest I've been put on hold was maybe 45 minutes to get my EIN. You can also apply for it online if you want to. 24 hours a day, I think, unless their site is down. Now, some people ask me, Mr. Silverman, every time I open up a new company, do I need a new EIN? Probably not. If you're the same owner, you can have many different companies under the same EIN. Now, I'll tell you one funny story before I give you your assignment. I got a call from an accountant the other day regarding a client whose taxes I prepared, and he said, Mr. Silverman, now I know you changed this guy's company from an S Corp to an LLC. That's because he didn't keep his corporation intact, he didn't pay his annual fee, and it was cheaper just to open up an LLC for him. And he said, now Mr. Silverman, what is the new EIN? I was blown away. This guy is a CPA, a certified public accountant, and he didn't know that by virtue of changing the state filing mechanism, this is at the state level, that the EIN number doesn't change. Once you get the EIN number, whether you change from an S Corp to a C Corp to an LLC to a sole proprietorship, doesn't matter. You still have the EIN. I couldn't believe that this guy was a licensed practitioner. I couldn't believe it. I actually called my client and I said, you know what? You better be careful. I don't think this guy knows what they're doing. Any questions about the EIN? One final comment. Sole proprietorship. It really doesn't require a filing. A sole proprietorship just means that the business is owned by one person. No formalities needed. You might want to file a form with the Secretary of State to protect your name if you have a great name. But what is a great name? I mean, I think Google's a great name. I don't really know what it means, but I always remember it. I don't know why a search engine is called Yahoo. I don't know why they came up with that name, but I'll never forget it. What's a great name? Something memorable. Something you want to protect. But keep in mind that the sole proprietorship offers zero asset protection. Zero. So anybody can reach into your personal assets if they file a lawsuit against you because you have no corporate protection. You don't even have the protection of an LLC. Okay, any questions about any of this before I give you your assignment? Yes?
Is the EIN international?
EIN, domestic, only for the United States. Yeah, it doesn't work outside the country. Good question. Yes, I got pretty good questions today. All right. Any other questions? Okay, beautiful. We can shut the camera down. Thanks, Joe.